Will the following fall under psychological incapacity as grounds to dissolve marital union? Abandonment by spouse of her family. Psychological incapacity as a ground to nullify a marriage under Article 36 of the Family Code should refer to no less than a mental, not merely physical, incapacity that causes a party to be totally incognitive of the basic marital covenants that concomitantly must be assumed and discharged by the parties to the marriage, which, as so expressed in Article 68 of the Family Code, among others, include their mutual obligations to live together, observe love, respect, and fidelity, and render help and support. There is hardly any doubt that the intendment of the law has been to confine the meaning of psychological incapacity to the most serious cases of personality disorders, clearly demonstrative of an utter insensitivity or inability to give meaning and significance to the marriage. Republic versus De Gracia, 726 Phil 502, 2014. The landmark case of Santos versus Court of Appeals, 310 Phil 21, 1995, taught us that psychological incapacity under Article 36 of the Family Code must be characterized by A. Gravity, B. Juridical antecedents, and C. Incurability. Thus, the incapacity must be grave or serious such that the party would be incapable of carrying out the ordinary duties required in marriage. It must be rooted in the history of the party antedating the marriage, although the overt manifestations may emerge only after marriage, and it must be incurable, or even if it were otherwise, the cure would be beyond the means of the party involved. In this connection, the burden of proving psychological incapacity is on the petitioner, pursuant to Republic versus Court of Appeals 335 Phil 664, or the Molina case, Del Rosario versus Del Rosario et al., GR 222541, February 15, 2017. In the case of Santos versus CA, Luell argues that the failure of Julia to return home after she went to the United States, or at the very least to communicate with him for more than 5 years, are circumstances that clearly show her being psychologically incapacitated to enter into married life. The Supreme Court held that the factual settings in the case at bench, as no measure at all can come close to the standards required to decree a nullity of marriage. Undeniably and understandably, Luell stands aggrieved, even desperate in his present situation. Regrettably, neither law nor society itself can always provide all the specific answers to every individual's problem. Marriage is not an adventure, but a lifetime commitment, and we should continue to be reminded that innate in our society, then enshrined in our civil code, and even now, still indelible in Article 1 of the Family Code. In the Molina case, the Supreme Court held the marriage between Rory Del and Reynaldo subsists and remains valid. What constitutes psychological incapacity is not mere showing of irreconcilable differences and conflicting personalities. It is indispensable that the parties must exhibit inclinations which would not meet the essential marital responsibilities and duties due to some psychological illness. How about illness? Will it fall under psychological incapacity? In Republic versus CA 335 Phil 664, the court laid down definitive guidelines on the interpretation and application of Article 36 of the Family Code, among others. It clarified that the illness must be grave enough to bring about the incapacity or inability of the party to assume the essential obligations of marriage, such that mild characteriological peculiarities, mood changes, occasional emotional outbursts cannot be accepted as root causes. The illness must be shown as downright incapacity or inability, not a refusal, neglect, or difficulty, much less ill will. In other words, there is a natal or supervening disabling factor in the person, an adverse integral element in the personality structure that effectively incapacitates the person from really accepting and thereby complying with the obligations essential to marriage. That he married Olivia not out of love, but out of reverence for the latter's parents does not mean that Regis is psychologically incapacitated in the context of Article 36 of the Family Code. In Republic versus Albios, GR 198780, the court held that motives for entering into a marriage are varied and complex. The state does not and cannot dictate on the kind of life that a couple chooses to lead. Any attempt to regulate their lifestyle would go into the realm of their right to privacy and would raise serious constitutional questions. The right to marital privacy allows married couples to structure their marriages in almost any way they see fit. To live together or live apart, to have children or no children, to love one another or not, and so on. Thus, marriage is entered into for other purposes, limited or otherwise, such as convenience, companionship, money, status, and title, provided that they comply with all the legal requisites, are equally valid. Love, though the ideal consideration in a marriage contract, is not the only valid cause for marriage. Other considerations not precluded by law may validly support a marriage. Republic versus Romero II et al. Dr. 209180, February 24, 2016. How about if the purpose of the marriage is to secure citizenship? The avowed purpose of marriage under Article 1 of the Family Code is for the couple to establish a conjugal and family life. The possibility that the parties in a marriage might have no real intention to establish a life together is, however, insufficient to nullify a marriage freely entered into in accordance with law. The same Article 1 provides that the nature, consequences, and incidents of marriage are governed by law and not subject to stipulation. A marriage may thus only be declared void or voidable under the grounds provided by law. There is no law that declares a marriage void if it is entered into for purposes other than what the Constitution or law declares, such as the acquisition of foreign citizenship. Therefore, so long as all the essential and formal requisites prescribed by law are present, and it is not void or voidable under the grounds provided by law, it shall be declared valid. Republic versus Albios, GR 198780, 2013. How about the act of bringing children to mahjong sessions? A mother's act of bringing her children with her to her mahjong sessions did not only point to her neglect of parental duties, but also manifested her tendency to expose them to a culture of gambling. Her willfully exposing her children to the culture of gambling on every occasion of her mahjong sessions was a very grave and serious act of subordinating their needs for parenting to the gratification of her own personal and escapist desires. She revealed her wanton disregard for her children's moral and mental development. This disregard violated her duty as a parent to safeguard and protect her children, affecting the development of their moral, mental, and physical character and well-being. Article 209 of the Family Code. The case of Calo versus Fernandez, GR 166357, January 14, 2015. In the words of the Supreme Court, to stress, our mandate to protect the inviolability of marriage as the basic foundation of our society does not preclude striking down a marital union that is ill-equipped to promote family life. Lastly, regarding affidavit of cohabitation, the marriage is void if it was contracted without a license. For Article 76 or Article 34 of the Family Code to apply, where in lieu of a license, an affidavit of cohabitation would be sufficient. It is required that the man and the woman must have attained the age of majority, and that being unmarried, they have lived together as husband and wife for at least 5 years. The minimum requisite of 5 years of cohabitation is an indispensable requisite carved in the language of the law. This material fact cannot be dispensed with, otherwise the marriage is void. It is not a directory requirement, but a mandatory one. In this case, they lived for less than 6 months. The affidavit was false. The marriage is void. Republic versus Jose Dayot, March 28, 2008. The next audio would be another important bar question area. So hit that subscribe button, be my subscriber, and do watch the ads too. Thank you.